I kept my hands flat on the table and breathed through my nose. My uncle's lawyer was talking, but I wasn't really hearing the words anymore. I was watching my uncle's face instead, the way the corner of his mouth kept twitching upward every time he glanced at me. Like he'd already won. Like this was just a formality. I had been waiting for this moment for 40 months. My father died on a Tuesday in late October. Pancreatic cancer. Fast, brutal. The kind that doesn't give you enough time to say everything you need to say. He was 61. He still had a boat he'd never taken out of storage. He still had a list on his fridge of places he wanted to drive to in retirement. Cape Breton, Tofino, the Icefields Parkway. He never made it to any of them. I'm 31. I work as a forensic accountant for a mid-sized firm in Ottawa. That detail matters. Remember it. My father and I were close in the way that people who've survived something together are close. My parents divorced when I was 9. My mother moved to Vancouver and rebuilt her life, which I don't hold against her. But it meant that from the time I was 12, it was mostly just Dad and me in that house in Kanata. He coached my soccer team even though he knew nothing about soccer. He drove me to every university campus tour in a single long weekend, surviving on Tim Hortons and audiobooks. When I got my CPA designation, he framed the certificate and hung it in the hallway before I even got home. His younger brother had always been around the edges of our lives, charming in the way that certain men are charming. Easy smile, good at arriving at the right moment, better at leaving before anything got hard. He never married. No kids. He'd worked in real estate for years, then consulting, then something vague he described differently depending on who was asking. My father helped him out more than once financially. I know this because Dad mentioned it quietly, not as a complaint but as a fact. He needed it. He's family. When Dad got sick, my uncle showed up. I'll give him that. He was there for the last 3 months, driving Dad to appointments at the Ottawa hospital, sitting with him when I had to work, handling things I couldn't. I was grateful. I told him so. I meant it. What I didn't know was that he'd been in my father's ear the entire time. The will was read 6 weeks after the funeral. I sat in a lawyer's office on Elgin Street and listened to words I hadn't expected. The house I grew up in, the house my father had paid off 20 years ago, was to be sold, with proceeds split equally between me and my uncle. My father's investment accounts, roughly $340,000 in RRSPs and non-registered holdings, were to be managed by my uncle as executor until I turned 35, with distributions at his discretion. There was a line about my uncle's financial experience and sound judgment. There was a line about my being at a transitional period in my professional life. I was 31 with a CPA designation and 8 years of experience auditing corporate financials. I sat very still. The lawyer kept talking. My uncle sat across the table and looked at his hands. I drove home and I did not cry. I made tea and I sat at my kitchen table and I thought for a long time. The will had been updated 4 months before my father died. I knew this because I'd seen an earlier version. Dad had shown it to me 2 years prior, over dinner, in the straightforward way he handled things. In that version, I was the sole beneficiary of everything, with a small bequest to a Parkinson's charity in memory of his mother. There was no mention of my uncle having discretionary control over anything. There was no language about my being in a transitional period. I called the lawyer's office the next morning and asked a simple question. Who had drafted the updated will? The answer was a notary my uncle had recommended. I am a forensic accountant. I know what document irregularities look like. I know what undue influence looks like in a financial context. And I know that when something doesn't feel right, you don't confront it at the dinner table. You build a file. I started building. The first thing I did was request a full copy of the updated will and all associated documentation from the notary's office. I was entitled to this as a named beneficiary. It took 2 weeks and a follow-up letter, but it came. I sat with it for an evening, going line by line. The language was odd. Not illegal on its face, but odd. Phrases that didn't match how my father spoke. Constructions that felt lifted from somewhere else. My father was a plain language person. He said what he meant. The clause about my being in a transitional period was the kind of thing someone says about a 22-year-old, not a 31-year-old with a professional designation and a stable income. I reached out to 2 colleagues at work. I didn't tell them why. I framed it as a hypothetical. If you were looking at a will that had been amended in the final months of a serious illness, what would you want to verify? They gave me a list. I already had most of it. Over the next several months, I did the following things. I requested my father's banking records for the 18 months before his death, which I was legally entitled to as a state beneficiary pending resolution. I contacted the hospital where Dad had received his treatments and, through the right channels, confirmed the dates and nature of his appointments. Not his medical details, but the timeline. I spoke carefully to two of Dad's longtime friends, men he'd known for 30 years, who told me separately that in the last year Dad had seemed confused about some things and that my uncle had been very involved in conversations they didn't feel they could ask about. One of them said quietly, "Your dad loved you. He said so every time I saw him. That's all I can tell you." I hired an estates lawyer, not a general practitioner, a specialist in contested wills and undue influence cases in Ontario. Her name doesn't matter. What matters is that she looked at everything I'd put together and she said, "This is worth pursuing." The process was slow. I want to be honest about that. There were months where nothing seemed to be happening, where I paid her fees and waited for documents to come back and watched my uncle send me emails about estate management decisions in a tone that was careful and just slightly condescending. He offered me $15,000 as an early distribution. A gesture of good faith, he called it. My lawyer told me not to touch it. I didn't touch it. What I found eventually was this. The notary who had drafted the updated will had a professional relationship with my uncle that predated my father by years. They had worked together on at least 3 property transactions. This was not disclosed during the will drafting process. There was also a question about the witness signatures. One of the witnesses was an employee of a company my uncle had a financial interest in, which created a conflict that, under Ontario's Succession Law Reform Act, was worth examining very carefully. My uncle had also, in the 8 months after my father's death, made 2 distributions from the estate accounts to himself, framed as executor fees, that were, by any reasonable calculation, well above the legally permissible rate. In Ontario, executor compensation is typically calculated as a percentage of the estate value, with guidelines. What he had taken did not follow those guidelines. He had not filed the proper executor accounts with the court. I put all of this in front of my lawyer. She filed an application to pass accounts, a formal court process that requires an executor to justify every financial decision they've made. She also filed a challenge to the amended will on grounds of undue influence and potential conflict of interest in its preparation. My uncle hired a lawyer. The lawyer sent a letter suggesting that I was acting out of grief and confusion, that I had always had a difficult relationship with my father's side of the family, and that my challenges to the will were without merit. The letter used the phrase, "emotionally compromised." My lawyer responded in the measured technical language that court documents require. I read her response twice and felt something settle in my chest. The day of the hearing was a Thursday in December. Cold. The kind of Ottawa cold that comes in off the river and finds every gap in your coat. I wore a dark blazer, and I brought a binder that I'd organized myself. Not because my lawyer needed me to, but because having it in my hands made me feel less like I was floating. My uncle arrived with his lawyer and 2 members of his social circle who I recognized but had never been close to. He nodded at me across the room. I nodded back. The presiding judge was a woman in her 50s with reading glasses on a chain around her neck. She had clearly reviewed the filings before we walked in. You could tell by the way she moved through them, not scanning but referring. My uncle's lawyer presented first. The narrative was that my father, in his final months, had made thoughtful decisions about his estate, that he had concerns about the stability of my financial situation, which was an interesting claim given that I had a professional income, no debt other than a manageable mortgage, and a clean credit history. The word stability kept coming up. I wrote it down on my notepad each time. They presented a letter supposedly from my father expressing his wishes in his own words. It was typed. My father, in every personal communication I had ever seen from him, wrote by hand or used email in the particular way of someone who learned to type in his 40s. Short sentences, occasional spelling errors, a tendency to put the important thing in the last line. The letter was none of those things. My lawyer stood up. She walked through the timeline, the notary's undisclosed relationship with my uncle, the witness issue, the executor fee calculations. She presented the banking records. She noted the dates of the amendments to the will relative to the progression of my father's illness. The final changes had been made at a point when his medical team had documented increased fatigue and cognitive fluctuation, not incapacity, but a window that someone who was present and trusted could use. She then asked the judge to look at tab 7 of the materials filed, a series of emails between my uncle and the notary that had been produced through the discovery process. I had read them. I knew what was in them, but hearing my lawyer describe them in the flat, precise language of a legal submission was something else entirely. The judge lifted her glasses off the chain and put them on. She read. The room was quiet. My uncle shifted in his seat. Then the judge set the papers down, folded her glasses back into her hands, and looked at my uncle's lawyer. She said, the timeline of amendments relative to the deceased's documented medical condition, combined with the undisclosed professional relationship between the drafting notary and the executor, raises serious concerns about the integrity of this document. I'd like to understand how the executor reconciles the fee withdrawals with the standard tariff guidelines under Ontario practice. I'd also like to know why these accounts were not passed before today. My uncle's lawyer began to speak. The judge held up one hand. She said, I'm asking your client. My uncle looked at his lawyer. His lawyer looked at his notes. The room stayed quiet for a moment that went on longer than it should have. What happened next took several more months, because that's how courts work. But the outcome was this. The amended will was set aside. The estate reverted to the earlier version, the one where I was the sole beneficiary. My uncle was ordered to repay the excess executor fees he had taken with interest. The matter of the notary was referred to the Law Society of Ontario for review of his professional conduct. My uncle did not go to jail. I want to be honest about that. The line between manipulation and fraud is sometimes thinner than people expect, and proving criminal intent is a different burden than civil undue influence. But he was required to account for everything he had taken, and he had to do it in writing, in front of a court. The house in Kanata sold in the spring. I didn't keep it. The upkeep, the memories, the particular weight of walking through those rooms without my father in them. It sold to a family with 2 kids and a dog. I stood on the sidewalk one last time before the closing and looked at the front door, which was still the same color my father had painted it in 1998, a dark green that he'd chosen from a sample card and never once second-guessed. I took the boat out of storage. He'd never used it. A 14-foot aluminum with a small outboard motor stored in a facility in Ontario since 2019. I paid the outstanding storage fees, had it serviced, and took it out on the Ottawa River on a Saturday in late July. My cousin came with me. My mother's side, someone Dad had always liked. We didn't talk a lot. We just drifted for a while, past the trees under a sky that was very blue and very still. Dad had a list on his fridge. I'd taken it when I cleared out the house. I keep it in my desk drawer now. I'm working on it. Cape Breton is next. I've thought a lot about what made the difference. Not just in the courtroom, but in the 14 months before it. And I keep coming back to something that isn't dramatic. It's almost boring, honestly. I just didn't react when every part of me wanted to. The night after the will was read, I wanted to call my uncle and tell him exactly what I thought. I wanted to forward the documents to every person at that funeral who had stood beside him and nodded. I wanted to do something that felt like doing something. I didn't. I made tea. I sat down. I thought about what I actually knew versus what I felt, and I decided to only work with what I knew. That gap between feeling and knowing is where everything either falls apart or holds together. I've seen it in my work too, in the files I audit. The people who get caught aren't usually careless. They're overconfident. They assume that emotional pressure will substitute for evidence. My uncle assumed that because I was grieving, I wouldn't look closely. He assumed that the version of me sitting across that table was the whole picture. It wasn't. There's something I want to say carefully because I don't want it to sound like a lesson from a fortune cookie. I didn't win because I was smarter than him. I won because I was willing to do the slow, unglamorous work of being right on paper, not just in my own mind. That meant paying lawyers' fees for months without knowing if it would go anywhere. That meant sitting across from someone I had trusted in a room full of strangers and staying calm while his lawyer used words like emotionally compromised in reference to me. It meant believing that the truth had weight. Not because the universe guarantees fairness, but because in a court of law, Documented evidence has a specific and reliable power that feelings do not. I think about my dad a lot when I think about this. He was not a complicated man. He paid his debts. He kept his word. He showed up. He helped his brother when his brother needed it, not because he expected anything back, but because that's what you do for family. And his brother used that goodwill, that trust, that final window of vulnerability to rewrite a document that wasn't his to rewrite. The contrast between those two ways of moving through the world is something I carry with me now. It's clarifying. What I know is this: the choices my uncle made didn't just affect a legal outcome, they revealed something about who he was, slowly, completely, in writing, in front of a judge. And the choices I made in response revealed something too. I chose to be precise when I could have been loud. I chose to wait when I wanted to move. I chose to trust a process I didn't fully control and to do my part within it as carefully as I could. The boat is in the water now. Dad's list is in my desk. I'm not the same person I was. The October he died, I'm not sure I'd want to be, but I know what I'm made of, and I know how I want to move through the world. That's not nothing.